Hello, everybody. It's great to be here and that you attend this lecture today on the Unified Patent Court, which is, of course, a very new system, and a lot of people are talking about that at the moment. The system is of great importance as it will cover quite a lot of countries in Europe, and so it will have a great impact on huge territory with a huge population with more than 350 million people and a huge market size with a 2 double-digit trillion amount of gross national product. So let's dive into this. And I will first give you a short introduction why UPC system is of such great importance, followed by a quick status update and by an overview of the UPC patent litigation system, and followed by some strategic considerations. So first of all, as you will know, we have, of course, European bundle patents, which cover up to 38 EPC states. And currently, in the current national system, with national litigation going on in several countries, we have litigation going on. We see quite a lot of litigation in Germany, as well as in the Netherlands and Milan and Paris and London. But the main litigation is really taking place here in Germany. And there was the problem that the length of the proceedings in the various countries was very different. So we had, for example, in Germany, quite quick proceedings for infringement proceedings, as you see here for Mannheim and Düsseldorf. On the other hand, in Munich, we had the Federal Patent Court with quite long proceedings. So you see that here, for example, 18 months in first instance and 27 months for second instance or altogether. And then in London and Paris, times were also quite long. So that is why they tried to have a different system. And there was also the problem that with the national proceedings, there were quite a lot of cases which were ruled differently in the various member states, so that we had some rulings, for example, in the famous Epilady case, which relates to a hair removal device. And we have seen some countries where the judges said the patent is not infringed, while others said the patent is infringed. So yeah, that is, there was really quite a big difference in the various states, and therefore people thought this should need to be amended, or this should be amended. So therefore they came up with the idea to build up a new litigation system, a European patent court, which provided, or which should provide, uniform jurisdiction and certainty as regards the rulings, so that there is not so much variation. It should also supply some cost savings and simplified enforcement. So speaking about the UPC, the question is really, where are we at the moment? And the UPC has just recently published its roadmap, according to which the court is supposed to open on the 1st of April. In addition, that means also that the sunrise period will start on the 1st of January of the next year. And that is quite important, because with the start of the sunrise period, for the first time, opt-outs can be filed. That means if you are, for example, the owner of a European patent, you can opt it out of the jurisdiction of the UPC. And the court will open for business then on 1st April. And that is the moment when, for the first time, cases can be lodged with the UPC. So what is the status of the preparations? We have, of course, we expect the UPC to be this new forum for patent litigation. And so far the preparations have really well progressed. We have seen in July the rules of procedure had been published then. And yeah, they say, for example, we have a new rule 5A, which says that, for example, an unauthorized opt-out can be, yeah, you can file an application to withdraw that. And then there are other rules which came up, for example, as regards the public access to the register and other things. Also, the divisions have meanwhile been confirmed by the court, and above all, what raised the interest of most people is that the appointment of judges has been confirmed, and I will come to that in a second on the next slide. Apart from that, also the so-called case management system was established. That means that cases can be filed in a certain software setting of the UPC, and that is making big progress. So everybody who wants to file, for example, an opt-out will have to use that system, and so really should themselves familiar with that. As regards to judges, we've seen that there will be 34 legally qualified judges and 51 technically qualified judges, and some appointments remain outstanding. There are many legally qualified judges which come from Germany. We have listed them here, and for example, Dr. Klaus Grabinski, who will be the presiding judge of the Court of Appeal, and also Patricia Rombach. They are very famous judges. They come from the Federal Supreme Court here in Germany. And also at the central divisions and the local divisions, there are quite a lot of German judges, which are very well known here amongst the German patent litigators. So even though there is no case law yet, that might at least give us some better understanding of what the thinking of the judges is, so that it might be a benefit, yeah, if you approach such a division where you know the judge. And where will it take place? We have a list here, a country map. Currently, we have these 17 countries as listed here. Germany has not yet ratified the agreement, so it's really keeping or working as a gatekeeper. So once the German instrument of ratification will have been deposited, then the sunrise period will start. As such, we expect that for 1st January 2023. The court is then supposed to open on 1st April. Yeah, that will be the case, except that there would be some kind of delay in the preparations, which is not expected yet, but of course you never know. And yeah, as said before, the impact of this system is really huge. We have an extreme great market. We have the figures here, and compared that also to the US, you see that it's yeah, very, very similar. And also as regards the population. So the new system will really have a great impact on huge territory. Therefore, it's really important that you understand the UPC patent litigation system. Therefore, I will give you now a short overview. So two aspects are of importance: the forum for patent litigation. That means the Unified Patent Court as such, which will give you the opportunity to enforce not only European bundle patents, which are already existing, but also unitary patents. And that is a kind of new right. And compared with the present system, the cost of maintaining such a unitary patent will be yeah, set around the cost of maintaining protection in 4 countries of European patents. So yeah, there are certain benefits or certain advantages. And yeah, whether you really want to make use of the system, therefore you should really be familiar with what the system provides. And it's supposed to to have exclusive competences. We've listed that here for infringement actions and also for counterclaims of revocation, which you might bring in those proceedings. The UPC will have also exclusive competence for revocation actions, where the defendant might also bring a counterclaim for infringement. Then we have certain provisional and protective measures and declarations of non-infringement and certain other actions. Apart from that, there will be certain actions for which national courts will constantly remain competent. That is, for example, a claim to assign the rights of a non-entitled patentee. We call that in Germany Vindikationsklage. It is, however, important to note that we have a so-called alternative jurisdiction at the moment. That means in the UPC agreement, which provides a lot of regulations and provisions for the UPC, there is a certain rule that is Article 83, which rules on the alternative jurisdiction. According to paragraph 1, it is for the so-called transitional period of which will last for 7 years and which might be extended for further 7 years. That alternatively the UPC and the national courts will be competent. On the other hand, we have in paragraph 3 the option that you can opt out your European bundle patents out of the system. Such opt-out is, of course, not available for the unitary patent, so that is important to keep in mind. But yeah, this paragraph 1, where the alternative jurisdiction is ruled, that is already raising some attention by the people in the patent litigation area, because there are, of course, already some scenarios where there is some kind of dispute, whether, for example, already pending proceedings, or whether you can bring proceedings in parallel or not. So there is some room for speculation at the moment. There's room for dispute, and that is something, which is very interesting to focus on once the system will have started, because I assume that will give defendants also room for argument, perhaps also to prolong the proceedings. Then we come to the structure of the court. You see in the bottom row, we have 2 instances. In the bottom row, there is the first instance, so-called court of first instance, and we have an appeal instance, the court of appeal, as you see in the top row, that will be seated in Luxembourg. And there we will have like 5 judges altogether, 3 legally qualified judges and 2 technically qualified judges. In the local divisions, we have local divisions, we have 3 legally qualified judges, and if the court assumes it to be helpful, then a technical judge can be added to the board, but that's not the rule. And that is also the case if you look at the regional divisions. That is built up in Sweden and the Baltics, which do not have a local division in each country, but instead we have this regional division. And then it's important to know that we have also a central division. There are supposed to be 3 central divisions, 1 in Paris, 1 in Munich, and we are still waiting for the setup of the third division, which was supposed to be in London. And due to Brexit, it won't be there anymore. So currently, a lot of people expect that might be set up in Italy, Milan, but it has not yet been confirmed. So we are waiting for that. And in parallel, there's also an arbitration and mediation center, which will be set up in Lisbon and Ljubljana. And their cases might be settled. So yeah, it has to be awaited whether there will be much use of that or not. As far as in Germany is concerned, we have not seen so much settlements because usually here it is practice that the courts ask, or the judges ask, the parties up front whether they might settle the case. And to be honest, I've never seen that so far. Then, yeah, so far as noted earlier, we have some local and regional divisions which have been announced. So this is just really a compilation, and you can read that on your own where the divisions are. It's noteworthy that, for example, in Germany, we have 4 local divisions, that is in Munich, Hamburg, Düsseldorf, and Mannheim. Whereas, for example, in Luxembourg or Malta, you do not have a local or regional division at the moment. Then, what about the jurisdiction? Where can you bring cases? So where's the venue of choice? As regards infringement actions, you can say you can bring those proceedings either in that state where you have a local or regional division and where the infringement occurred, or as an alternative where the defendant is domiciled. And as regards counterclaims for revocation, they might even be transferred to the central division. That lies in the discretion of the local and regional divisions. But a lot of people say, well, there is still room for bifurcation, as that is known from Germany. But I would not really expect that to be used, but you never know. The central division, that is the division to be taken for standalone revocation actions and associated counterclaims. You can also bring infringement proceedings there. If, for example, a defendant is a party which is domiciled outside the territory of the member states. And on the other hand, if infringement is taking place where there is no local or regional division, and we had noted that on the slide before, that is, for example, the case in Luxembourg and Malta. So if you have an infringer there, you would go to the central division. And then it's really a very frequent question that people ask, well, what can I obtain? And you have certain preliminary measures, such as preliminary injunctions. You can ask the court to seize evidence or to inspect premises and to freeze assets. So that is really very, very important. On the other hand, you see in the second column, we have certain measures which you can obtain during infringement proceedings. And there are, of course, permanent injunctions, which are of most importance. And then a declaration of infringement. You can recall infringing items. And you can also request the destruction of the products. So that is very, very similar to what we are known to from the German proceedings. And the third column, that is, of course, also of great importance, an award of damages. So, and also as preparation for that rendering of accounts, that is also very important, so that you can calculate the damages. And then, of course, the defendant will usually, what we expect is to launch a revocation action or a counterclaim for revocation, and accordingly, defendant can ask the court to either entirely or in part revoke the patent in suit. The patent can be limited by amendment of claims. So there's quite a broad range. And there's also like the determination that there is no infringement, but we really kept this here really high level. So that's not all in here, but there are some more things which you can obtain. And then it's of course important to know how long will the proceedings take. And if we look at the infringement and the revocation proceedings, which are the most important ones, there is a split. We have first a written procedure, which is supposed to last around 9 months. Then we have an interim procedure where the judge rapporteur will prepare the oral hearing. He or she can align with the parties and say whether something is still missing, so that the parties add on something. Yeah, and then 6 weeks after the oral hearing, the court shall issue its written decision. So that altogether, first instance proceedings will really last around 1 year. And the proceedings are really pro-patentee or pro-SPC owner, because as you see here, the written proceedings, there are quite tight deadlines. For example, as you see in the upper row, for infringements proceedings in first instance, the defendant has to file the statement of defense within 3 months. And if you consider that the patentee can prepare the statement of claim for during a much longer time, for example, like 1 year, then you must really say that it is pro-patentee, because it's really challenging for defendants to prepare the replies. And you might also need a big team to prepare that. So if you are the potential infringer, or if you expect to be sued, it's really something where you should prepare the arguments very quickly. The same type deadlines exist in the revocation proceedings. On the other hand, that is now the patentee in the position of the defendant. Again, there is a short deadline of only 2 months. But of course, if you are patentee and if you decide to bring infringement proceedings, then you can expect that there will be a revocation action, and you can, of course, prepare for that. Yeah, and then as said, in infringement and revocation proceedings, you have a first and second instance, and what usually follows thereafter are the damage proceedings, where the court has to rule on the amount of damages. So that is not in the same proceeding, but it's a second separate proceeding. And also the proceedings to determine the costs are separate, and I will come to that in more detail in a second. Then we have also, as noted, you can obtain provisional measures, and again we have a written procedure there, where you need to identify what is requested, and the court needs to take all the facts and evidence in account. So you really need to prepare that very thoroughly if you want to bring such proceedings, for example, requesting a preliminary injunction. And the court, it might rule ex parte, but it might also request an oral hearing and summons both applicant and defendant to such hearing. There's also an option for potential defendants to file protective letters in advance. It's not yet clear when you can file that. That is something that needs to be clarified, because so far we have learned that this case management system, you can try it already. It's like a testing system is available, but it has not been yet announced by the court when a protective letter can be filed, because they said the system will be cleaned after a certain period before it finally starts, and therefore everything you would file before the start of the UPC will be removed, and not sure how they want to handle that with protective letters. Yeah, and then as regards the preliminary injunction as such, we expect that also urgency might play a role. Of course, then, yeah, infringement will have to be considered as well as the validity of the right. But we do not yet know what urgency means. We have certain case law in the past in the different nations, and yeah, also as regards the validity of the right, we have seen that, for example, the federal, the court, CJ court, the European court had to decide a referral from the Munich court, whether a very young patent can also be part in PI proceedings, so that there were some guidelines and the UPC will have to take that into account. But yeah, it still remains to be seen what the court will finally make out of it. As regards the costs, you have the system that the loser has to bear the costs, and those consist of court fees. Then you have, in addition, the attorney fees and also patent attorney fees. You might have costs for experts and for translations of the submissions and also for the witnesses. There are certain cost ceilings, they need to be justified. And for example, as regards the court fees, you should also know that there is a split. We have fixed fee on one hand and a value-based fee on the other hand. There are certain cost reductions which are possible. For example, if you withdraw the action at a later stage, there would be a reduction, and there are some other scenarios. And as said before, losing party has to pay the costs. And I have some examples for the fixed fees. For example, for the infringement action, we expect 11,000 euro. For a counterclaim for infringement, that would be the same. Revocation action, 20,000 euro. So that's, yeah, very, very clear. And on the other hand, we have value-based fees as noted, and I have picked up some of them. So it really depends. If you have up to 500,000 euro, you don't have to pay any value-based fee, and thereafter it slightly increases from 2,500 up to 325,000. Yeah. On the other hand, if speaking about costs, it's also important to know if you decide to go the route for unitary patent, that is of course a bit cheaper if you request compared to the maintenance fee for European countries. So it's really what you see here. Unitary patent is the dark purple shade, whereas if you request, request a European patent for 26 European member states, it's much higher. But that is not what we usually see. I mean, in the tech space, we often see that patents are filed in 3 countries. That is like Germany, France, UK. So that's really the light purple color. And if you are a patentee which would request or who would request only like unitary patent for those 3 states, then it is cheaper than a unitary patent. On the other hand, if you request like 4 or more nations, a European patent for 4 or more nations, then the unitary patent is cheaper. So the question is really, do you want to make use of this system? And as we see, there are quite a lot of aspects which play a role. You have to understand the UPC system. That is what we have done so far, where we have had this overview, and then you will have to weigh the advantages and the disadvantages, and also the individual strategic aspects. So that is what I want to discuss now. And as regards the advantages, it's of course nice. If you are a patentee, you will obtain one title. You can enforce that one title in all the participating member states. So it's quite easy, or supposed to be easy, to enforce such title. It's also supposed to be more cost effective rather than litigating a patent in various nations. And it is supposed to be very quick. Just a reminder here, we have, for example, in Germany, infringement and validity cases, which take much longer than the expected 1 year in front of the UPC. However, these advantages, let me say where light is, there's also shadow, and there are certain disadvantages. I mean, if you are a patentee and you can obtain one title, that means also your patent can be revoked with one single decision. And when it comes to enforcement, it all sounds very good that you can enforce this one and single title in all the countries which take part, but that has not been road tested. So there are still uncertainties. And with regard to the judges, we have discussed that earlier, that there will be certain, certain German judges which we are familiar with, but finally we have no case law yet, and it is the benches will be composed by a multinational panel. That means apart from the judges coming from the nation of the division which is used, there will be also someone from another jurisdiction. And if you imagine that there's someone coming from a country where there is not so much patent litigation going on, then you can imagine that such perhaps rather unexperienced judge, it's difficult to predict the outcome. And so there remains a big question mark of what case law we will see and how the cases will go. So in a nutshell, there's really this big threat for patentees, and that is what I really hear very, very often, that they don't want their patent to be revoked in a single stroke for all these participating member states. And so it's really important that you decide now whether you are so scared that you want to leave the system, or whether you see certain benefits and want to make use of it. Anyhow, there are certain individual strategic aspects which play a role in this context. And first one is, of course, where are you seated and where is a potential licensee of yours seated, because you are earning perhaps royalties from such licensee. And you need to consider what products do you have, which patents or SPC protect the product, and where do they exist. So that will give you really a first feeling of how many nations might be included and how many parties. And that might give you also an impression of how costly such proceedings might be. Rather, if you compare the national route with the UPC route. Another big aspect is, of course, the question of the validity of the patent. So you need to assess how strong are the patents or the patent portfolio, which is the relevant one. And if the patents have survived already opposition proceedings, that might be a good indicator. But also, other factors might play a role. So that is something you really need to address individually. And also the question whether you expect the competitors, depending on where they are seated, whether you expect them to launch a nullity action in response to an infringement action, or rather not in response. Some competitors might even file a revocation action to clear the path for the launch of their product. So that is also an important aspect. And yeah, you also need to consider what is the economic impact of a revocation on your business. And yeah, then you might want to take also perhaps a split approach to mitigate risks. And what does that mean? You can, of course, if you have like a patent family, you can decide that you can leave one of these European patents within the UPC system and perhaps opt out other patents of the family, so that you can go the national route and the UPC route in parallel. So that might be a good idea if you have a large portfolio. And last but not least, some people also say that they want to shape the case law in their technical area. So that might be of interest for you as well. If you finally decide to opt out, that is something you should also prepare now. With regard to timing, when is the opt-out possible? Well, for the first time, when sunrise period starts, that means from 1st of January of next year. And then when the court has opened, the opt-out will still be available, but you need to differentiate. We have the transitional period, which will last 7 years for the first time, and then it might be extended up to further 7 years. And during the transitional period, you can still opt out European patents or opt them also back again in. You cannot opt out your European patents at the end of the transitional period. But what is important to know is that once you have filed an opt-out, that will remain in existence even after the end of the transitional period. So that any opt-out filed will have effect even thereafter. The opt-out as such is only available once. That means you can opt out of the system and you can opt in. That is the so-called withdrawal of the opt-out. And also the opt-in is, of course, only once available. So once you've opted out, opted in, you cannot opt out anymore. Also, there are some further limitations you should be aware of. If you let the moment pass by when the UPC starts, and if you don't opt out your European patent, and if a competitor files, for example, a revocation action with the UPC, then there is no more option to opt out of this system. On the other hand, if you opt out your European patent and if a national action would be brought in one of the participating member states, then you cannot opt back in. Yeah, and then in addition, with regard to the opt-out, there are also some other requirements. It's important that all co-proprietors of the European patent and the SPC have to agree. So that is something, if you want to opt out, you should check whether you need such consent. And also, if there are different owners of patents which originate from the same European patent application, then also the owners of rights in non-participating member states must agree. And that is really important because that could mean that quite a lot of different owners have to agree. And also, if you have a supplementary protection certificate, which is owned by someone else and not by the patent owner, then you need also the consent of the SPC holder. So let's speak what's happening if you are a licensee. It's important to know that you yourself cannot opt out the patent. That is something you need to discuss with the patentee, because only the patentee can opt out. When it comes to filing actions, there is a differentiation. The exclusive licensee can bring an action in front of the UPC if the patentee is given prior notice and unless the licensing agreement provides otherwise. It's rather the other way around for the non-exclusive licensee that can usually not bring an action in front of the UPC, except that in the license agreement there is that is ruled otherwise there. And again, then the patentee also needs an upfront notification. So that is really important that if you are a licensee, that you discuss with the patentee the strategy for the opt-out and who shall bring the proceedings. And therefore we highly recommend that you check your license agreements and check whether a renegotiation is required, and that you consider what to say in the license agreement, because you need to address who can also select if you want a European patent or unitary patent, and who can bring the infringement proceedings, and then you will have, of course, the original clauses or the usual clauses. So I was asked to leave room for questions, and that is what I do now. Unfortunately, I don't have the camera on today. That is due to technical things, but happy to discuss.
Thank you very much indeed for that. Just to reiterate to our audience, the Q&A tab is at the bottom there, so you can submit some questions and then we'll call on you to ask those. Perhaps I can get the ball rolling whilst those come in. You've spoken about some uncertainties about the judges that have been appointed. And at a previous webinar, one of our panelists raised some concerns about issues of conflict of interest, given that some of those technical judges are current practicing patent attorneys. I wonder what your perspective on that is. Do you think that that's a valid concern? And do you think perhaps structures are in place to adequately mitigate against that? Or do you think there's more that needs to be done there?
Yeah, that's a good question. And I've also seen that was discussed in the patent litigation forums or in chats also in the internet. I mean, that was also my feeling when I first saw the list. Everybody was curious, what is the list? What does it look like? Who will be there? And of course, there was big discussion as regards the legally qualified judges. But when it comes to technically qualified judges, I was also surprised. They are really from private practices people, but the ones that I've seen and that I personally know are really people who know what they are doing, who are very, very experienced, who have a good feeling and a good understanding of patent litigation. So I really believe that there was a choice taken, or which I assume was very reasonable and sensible. Nevertheless, there is of course a little bit of flavor in this, because people are still in parallel sitting in their private practices. And so I mean, that is something where other people, I've read some comments where people were concerned that there is such technical judges might use that as to advertise and to sell their practice, which is of course, I think it's reasonable, even if they would not do so. I mean, you will know over time or during time that those people are judges. And I mean, my personal view is you might consider that someone being a judge that is highly qualified. So I mean, it depends. It will remain to be seen what the final outcome is, and also how much use will be made of the court. So I can imagine if the court is getting more speed, And if it's getting more busy and more busy, then people might even have to decide whether they want to do such split approach, being a judge and being a patent attorney in a firm, or whether they would have to really split up and decide to proceed only with one of that.
We've had a question from an anonymous attendee who says, if technical judges are part-time and are not remunerated, why could they not have another job?
Yeah, I mean, that is my understanding, that they are part-time and they have another job. And I think, yeah, I mean, that is, of course, the point. If you are only part-time judge, you will also have to earn your living. And I don't know what they will be paid, but yeah, I mean, that's the way it is at the moment. So, yeah.
Interesting. And given the given some of the risks, perhaps, that you outlined of opting in, do you think that patent holders will go for this, or do you think actually they'll view the risks as too substantial for them to really buy into this project?
Yeah, I think it depends a bit on who is the patentee. I've heard from some really big companies that they want to shape the law in their technical area. That are companies which have really huge amount of patents. So I can imagine that if you have really a big patent family on protecting a product or a certain manufacturing method, then there might be some patents where you can say, well, of course, I have enough other patents. I try the court and I give it a test. But there might be also other companies which have not such a huge and broad patent portfolio. And I understand that, some people also say, well, I want to watch from the window. I want to see which direction the court is going. What will the people decide? And also at the beginning, I mean, it's the starting phase where you don't know which direction is it going. I assume once it has, gotten up to speed, then it might be easier to decide for the system. And I mean, you can opt out, watch, and then opt in again, provided that there are no national proceedings. But I can imagine that quite a lot of people will look from the window. And what I also heard is, like, in the pharma area, life science area, some people say, well, we don't want to use the unitary patent at the moment because there is no unitary supplementary protection certificate. The SPC is missing. So that is really something that is a big downside at the moment. It's expected that will come in at a later stage, but it's not clear yet when. Yeah.
And related to that, we've had a question: do you expect national proceedings to increase in Germany?
Yeah, if that is, I mean, I understand national proceedings is not the UPC proceedings. We've seen quite a lot of cases in front of German courts. So, I mean, there is a strong venue for patent litigation. I expect that will remain consistent, irrespective of whether you use the national route or also the UPC route. Having spoken about the judges, I can imagine that people would be keen to go to divisions where they are familiar with the judges and where they expect some reasonable decisions, even in the new system. So, yeah, I mean, if the UPC system will be used, then in the long run, national proceedings should decrease. But apart from that, I don't know whether there will be an increase due to the UPC. That remains to be seen.
That really is the summary of it, isn't it? It remains to be seen.
Yeah.
Thank you very much for your time today. We've really appreciated that. That's been a really useful and valuable talk, I hope, for our audience. To highlight to you future webinars that Oxford will be hosting, we regularly publish on the important IP matters of the day, and we host webinars such as this. The website and our LinkedIn page are the best place to stay up to date with those. Thank you for attending today. Thank you, Dr. Brambrink, for your time, and we wish you very well for the rest of the day.
Yeah, and thank you also from my side. Thank you for listening and letting me speak. Goodbye.
Excellent. Thank you. Bye-bye.